Call Fergus Ewing to wind up. Minister, you have 8 minutes.
Thank you very much, Presiding Officer. I'm very grateful to all members for their contributions to this debate, which I think have been extremely useful, at times thoughtful, perceptive, and coming at the issue from a very large number of different perspectives, which has been useful. So I thank all members for that at the outset. We have, as I think our response to the committee has clearly demonstrated, sought to show not only have we listened to the committee, but we have responded to the committee and responded by and large positively to most of the points that the committee has made, and many of these have been repeated in this debate. It seems unreasonable that the Citizens Advice Bureau should not be able directly to employ solicitors. I think Mr Maxwell mentioned that today. A removal of that restriction would seem to be sensible, easy to effect, and I hope will be done at stage 2. The committee recommended an enhanced role for the Lord President. We've given that careful consideration. We agree with the committee and the arguments that it adduced to that end. That too will be brought forward. At the very outset, I think I indicated to the committee that it's imperative that the new structures brought forward under ABS should be subject to protection of clients in exactly the same way in principle that exists at present, both in relation to negligence but also fraud. I did make it clear in my evidence at stage 1, so far as I recollect, that at stage 2 it was, in my view, necessary, therefore, to bring forward provisions for a compensation fund so that clients of the new licence providers would receive protection against fraud. So that protection will be brought forward, as was raised rightly by a number of members in this debate, at stage 2. In addition, Section 35 and the step in powers of ministers to act as regulator in the event of default of approved regulators for whatever reason was only intended to be a last resort. Amendments will be brought forward to make that clear. Mr Maxwell mentioned sanctions on outside investors, and I think that was also mentioned by speakers from this side of the House as well. And I think the argument is well made, that there should be sanctions to be used against individual outside investors. That will be the subject of amendments that we brought forward at stage 2. In addition, I have decided that, although it is perhaps not strictly necessary, I am told by the legal experts in the Scottish Government, because it is already implicit in the terms of Section 2, I think Section 2, subsections C and E, from memory, which could of course be failing or fault, that I think it should be said on the face of the bill that those who are working under the new licence provider's business structure will be subject to the same duties of confidentiality that are owed by solicitors to clients in traditional solicitors' practice. And I think it is important to make that clear, so that, as has been said by many members, it is clear that we are aiming for the highest ethical standards to be provided by all of those who engage in alternative business structures. That is the type of business that we envisage being done, and that is the type of approach that we will require to be carried out. I think it was Nigel Donn who pointed out to the terms of sections 1 and 2 of the bill, and these are the first and second sections because of the importance we attach to them. The regulatory objectives, which is set out in section 1, to support the constitutional principle of the rule of law, the interests of consumers, the public interest generally, access to justice, which Labour members have quite rightly highlighted as a very key objective. That is why it is set out in section 1 of the bill. And section 2 of the bill setting out professional principles, principles which all solicitors hold dear, to act with independence and integrity, to act in the best interests of clients. So I hope that in this response to the debate, I have indicated that we have listened to all members, that we are responding to their points, and we are responding to the points by, in most cases, doing exactly what is asked of us. I would like specifically to address a point that was raised by Richard Baker quite fairly about claims management companies. Let me say that we have no fixed position on this. We see the case on it. I would very much welcome the opportunity to meet with Mr Baker, and let me say why I think it would be particularly useful to meet, even if in advance of stage 2. That is that we are aware of concerns relating to claims management companies, but we are not aware of much evidence of malpractice in Scotland. We know of about 4 or 5 complaints about such companies, but we do not know whether they can be substantiated. At my request, officials have made inquiries of the OFT, Trading Standards, Citizens Advice, Consumer Council, former Consumer Council, Law Society, but we do not detect a huge amount of evidence. If there is evidence that you have, we would like to see it. It may be that this bill is not the correct vehicle for addressing this. I do not quite know whether it would be a competent amendment, although that is not for me to decide, Presiding Officer, but your own office. But nonetheless, we would wish to engage with you on that issue and respond to those concerns. I would also like to make it clear, just in case there is any doubt, that as I said in my opening remarks, I have had useful discussions with the profession itself. I was determined so to do when taking over responsibility for the handling in Parliament of this bill, and therefore I think by my arithmetic I have had 11 meetings with various interested parties, including several representatives of the legal profession, the Scottish Law Agents Society, the Law Society, Mike Roberts, individual solicitors. I do intend and have already arranged and indeed had sought further meeting before the referendum. I am to meet with representatives of individual firms. I am to have a further meeting with the Scottish Law Agents Society. Like all members who have spoken in this debate, it would be preferable, highly preferable, if we can secure, if you like, broad support within the profession for our proposals. Whether that is an objective that is achievable is something I would hope to aspire to, but I am not going to predict at this stage. Suffice it to say that the attempts that have been made thus far have, regrettably, for whatever reason, not yet been successful. But further meetings will take place. Presiding Officer, as I wind to close my remarks, I would like to say, and echoing I think the sentiments that have been expressed by members in all parties in this House, that those involved in the Law Society have carried a huge burden over the past year. They have faced a very difficult time. I think the torrid time was the expression used by Mr Brown. Mr McLetchie also referred to, as did Mr Baker. And I would like, in closing, to pay tribute to Ian Smart, who will shortly demit office as President of the Law Society. Ian has worked tirelessly to promote the interests of the legal profession and the public in relation to this bill and on many other matters. As sole practitioner himself, Ian clearly has the well-being of all solicitors at heart, and I have no doubt that in his remaining time as President, and I think he is watching up in the gallery here today, he will continue to work hard on their behalf, and I thank him for his extremely constructive contribution over the past few months. I commend the principles of this bill.
Thank you, and that concludes the debate on the Legal Services Scotland Bill.